Each party will be provided with 1 hour each to speak, so please let us know your time allocations.
And distinguished members of the tribunal, good afternoon. I'll be addressing this honorable tribunal. A foreign qualified investor did what any other investors do: take the risk to venture into new markets by relying on an existing VAT that was ratified on 30th November 2005, which was between the Tehran and the government of Mahadi. However, the hopes of our clients.
Counsel, assume that we have understanding of the facts of the case. Please dive into your second issue.
My second issue.
Yes.
Much obliged, Chief Administrator. My second issue purports that the first, the second, and the third claimant possess the prerequisite local standing to pursue these claims. Honorable arbitrators, in order for us to be able to establish that the second and the fourth claimant and the third of before annual report, which provides for the corporate structure that our client indeed was. The first claimant owns 90% of the shares that are present in CryptoFlix Marketing Limited. It is my firm position that on the evolving jurisprudence of international investment arbitration, besides the primary risk of the investment. In assessing to the affected entity.
That is a direct investment. Can you expound first what is the investment in this context and any source that gives you validity of the submission?
In reference to the form of assets that are protected as investments. So in this aspect, for the second claimant to have an investment, it is 90% of shareholding that it possesses on the first claimant, which is the affected entity. And I support this by position to navigate or to deny local standing by simply seizing the assets without seizing the shares of the claimants. But the tribunal held that once you seize the productive assets of the company, automatically you diminish the values of the shares, which are the form of investment that the shareholder owns to the affected entity. And it is in this light I'll proceed to my second test that tribunals have consistently applied in determining whether a shareholder, Amco Asia, because Amco Asia was the parent company that owned majority company, well, the Amco Asia was the subsidiary. So the tribunal held that because, moreover, the tribunal did find that between Amco and this benefit, now the benefit of being protected.
And would you relate those circumstances to the present case?
Finally, to determine the economic reality of the transaction, which in the case of, because Universal versus Russia. Therefore, the economic value of the investment itself. I'd like this tribunal to refer the case of Gami Investment versus Mexico. In these assets, without seizing the shares, will render protections and Act 110 of the NAFTA illusion the shares by simply attacking the company itself. It is undermining the economic value of the enterprise. Consequently, the shareholders have confirmed that shareholders' interests encompass not only their former rights, their mutually excessive $6 billion tax has directly impaired the
Harmed, or are they directly harmed as well?
They are directly.
They're all directly, all together.
I've finished my submission of the third claimant as the majority shareholder. So I'll be proceeding now to my submission on the group of companies doctrine. It is in this case that the Tehran Mahadi VAT does not obtain advantages and is not legitimate. So 99% the first claimant to acquire the required juridical conditionality, and as per the statement, it is not illegitimate. Proceeding, I will now be proceeding on my first step. Honorable arbitrators, I call upon this tribunal to interpret Article 82C or to be bound by arbitration for a further 2 years, and the prerequisite requirement of consent has been signed, and the case was about oil concession agreements plus foreign investment rights.
Do you have a continent specifically in West Africa, just?
Well, Article 35 permits this tribunal to apply appropriate laws that it deals with. So the first claimant possesses the required juridical nationality of qualified investor as the first claimant is fully owned and controlled by qualified investors from Chile, which is sufficient to invoke the foreign control test that is a risk of where those companies, where those subsidiaries are incorporated. In our case, crypto-fees invoke the case of the suspect at the time as A versus the Czech Republic. If you can
All the three claimants, qualified investors, or one of the qualified investors.
as I'll which at the end of the day it owns crypto-fees market. This channel brings technology and Act 1.2 of the 2018. 90% of interest of share or all the shares that are owned by crypto-fees.
Question of incorporation. What qualifies it?
So in the context of international investment, there are two things. The provision of the VAT requires a company to be owned by Honorable arbitrator. When it comes to the VAT provides a Pandora box because it does not limit. That's why we have came up with the control test from terrain based on terrain control test.
Council, I'm just asking you to refer to the words of the VAT, because if I may take you back to the rules of interpreting legal provisions, I think you need to read what's in the law first, rather than inferring to it. So referring from the law, where do you establish ownership as a basis for qualification, is what I'm asking.
And Act 1.2, it provides that a company incorporated in Chile or Marhabi or its legally registered subsidiaries.
So if I'm reading this, the basis is incorporation or registration, not ownership.
For the parent company, the basis is incorporation. But for a subsidiary, now it comes in the foreign control test. Because it does not limit and its legally registered subsidiaries. As we are keeping on trying to perform its duty obligation in good faith by the plain meaning of the VAT, it is already owned by the parent company. So, proceeding to my third sub-issue.
So then turn you to that position because I'm slightly confused. So can we address it one by one? Claimant number one. What makes claimant?
The first aspect is the juridical nationality of the interpretations of a treaty. Proceeding on my issue on
Private company limited provide that connection.
is the Chilean entity because it is incorporated.
So which is the Chilean entity? Which one? I'll rephrase that. What makes a Chilean? We're struggling to understand that because the tax entity at the end of it all, this originated from a tax dispute. The entity, a qualifying investor. I'm limiting my question to claimant number one, who's a Mahavi incorporated entity. Can you please repeat your answer?
All companies they require juridical nationality, and my response was from the company from Chile because it is exercised bias the required juridical nationality of the qualified investor under the principle of foreign control test. Also, proceed. Honorable arbitrator, to respond to that question, all can refer to a certain state, and it is owned by foreign investors. So, proceeding on my issues on feasibility, I'll humbly submit on two grounds: accessible and reliable. Also, under Article 3.1e of the Chilean VAT, there is of providing effective interest. In the circumstance at hand, our client, indeed MRO, who said that any assessment will be upheld up to the Court of Appeal. But also,
let's move around a metaphorical story. Basically resulting also an unreliable result. Out of that, the results would have been unreliable. We've seen circumstances whereby
the chief arbitrator responding to that question, I want to be invoking assertions or any assumption that the available remedies were not available, were not genuine convenience remedies on the following grounds: that the Argentine judiciary lacked independence and was vulnerable to claims of denial of justice. The requirement to exhaust local remedies forms a part of the
less than 2 minutes. So let us understand the substance of this idea.
7, sub-article 4 of the universal rule, which provides that this tribunal, I'll address it very briefly. On the side of the respondent, the denial of justice, violation of treaty provision aligned. Much aligned.
Madam President and honorable dignified members of the tribunal, agree on 4 sub-issues. The first one is on creeping expropriation, fair and equitable treatment concerning the deliberate attempts in order to eliminate crypto fleets marketing in order to establish the state. It's the principle of no non-tributants in the leg. It's based on the principle of legality. By the way, crypto fleets marketing. And this creeping expropriation is taxation. Furthermore, I draw the attention of this honorable tribunal. Furthermore, this arbitral tribunal, may I draw the attention to criticizing the taxation measures, asserting that it's an extraterritorial overreach. Now, why am I saying this? This is because the Finance Act did not categorically recognize digital. May I also draw the attention of this honorable tribunal?
So, Council, can you repeat your message about notice, right? Did I hear you
It's
correctly?
about the initial tax assessment notice.
Yes. So dealt with this much. I mean, if it was in your opinion to help us understand from your notice that may or may not have been reported in this stage.
The thing itself categorically states that engaging in crypto. On this aspect, may I draw the attention of this honorable tribunal based in the case 7, sub 4, the ancestral model.
Counsel, I want to take you back. So you've admitted before this.
I have to request this honorable tribunal to take that out.
Notwithstanding any provision of this Act, where the Commissioner General is satisfied, I can allow your counsel to give you to refer to this. So are you telling us here
Arrangements in order to mitigate taxes. So, may I also draw the inspiration? The provision itself says that the Commissioner General is satisfied, assessment. And then what can actually be seen is that the sudden termination.
At some point, we started talking about the impact of non-recognition of digital assets because the Finance Act refers to having more recognition of digital assets and how that is important for your team.
Much obliged, Honorable. And furthermore, may I draw the attention of this honorable tribunal based on Article 138 of the Constitution.
In charge, the recognition of digital assets was before we looked at articles of the Constitution.
Much obliged, Honorable Trader. Thank you for that and legality. Because the Finance Act itself of 2023 is silent in that aspect. So,
The client taxed for, and the service that you were taxed for, was it digital assets?
that crypto-flex marketing was assumed that it's trading when in essence it is not. Sitting on capital gains tax, this is based on estimated profits from the app users.
is doing? I want you to show us, just read what is in the assessment.
Now, this is where the controversial aspect comes in. This is because we all
Apologies, as one further question for me. Is digital trading the same as the background says on services rendered by crypto-flex marketing company? Comment about the taxation of digital assets. Therefore, when we read the notice was it trading of digital assets? Because those are two distinct things.
who was the ultimate recipient of these marketing services? This is the question. So,
Counsel, one last question.
crypto-flex marketing be engaged, be taxed to the gains of its clients.
As per Mojave law, what provision establishes capital gains tax?
It's based on section, I still maintain the submission because crypto-flex marketing, which were actually conducted in Ghana.
So am Mojave taxing profits or this?
And then another additional layer is actually being imposed in Mojave. So this contradicts the Finance Act.
Not the Digital Service Act.
I have understood. Thank you for your guidance. Finance Act of 2023? No, it does not. It's the Finance Act of 2024, which now stipulates.
You've used them interchangeably. I just want you to clarify if there's a difference.
Yes, when this should actually be taxed at the rate of 2%. Honorable Trader, I humbly made your attention based on the Central Bank of Mojave notice. And it supposes that an investor should reasonably be able to know what are the rules and regulations which the Central Bank of Mojave. And states under international investment law do have a duty.
Expectation. What was legitimately expected by you?
Based on Article 3.1, categorically states there is an aspect of notice.
What should have the state of Mojave done for your client to
Maybe economics or maybe whatever that can be done in service. But what can actually be discrimination? This is because crypto-flex marketing was not paid. Suddenly, a regulatory ambush and tax being weaponized against our clients. Our clients have suffered.
Notice before issuing tax audits to investors.
1B, they actually have to be interpreted based on the doctrine of harmonious construction. Possession. And I absolutely do this.
So you shocked by the findings?
The blatant and the flagrant breach of the VAT of these provisions. Why?
You said the word excessive. I just want to know what is your basis for saying it's excessive?
Also, you told me a lot of people were discriminatory, excessive. So what was the third one that you used?
Do you have any way to show this tribunal that this amount of money?
Speak in one sentence. In what manner was the taxation discriminatory? Sorry, what was the
On physicality.
that? Relative to what?
And that's what they've been rooted. It's to be trademark. This is a state 6 billion. What does that amount to? This shows that how does the word favorable treatment mean? This means free and establish endings and endpoint. So
2 minutes to wrap up.
much obliged, Honorable Arbitrator, for all our clients. And in light of this, I pray before you my submission.
Submission, I'll spend 27 minutes while discussing the first 2 issues. And this case is not just about the state standing against the institution to determine this matter. Considering the national.
So I'm just curious. Areas of facts that favor them. I'm curious as to.
Claimant, Crypto Company Limited, and Crypto Company Limited has a local standard to bring forward automatically because a company is a separate legal entity from its shareholders. It's quite a marketing company limited. This fact has also been this company. To bring this claim before this honorable tribunal. Coming to the second thing, still our client would not have a question to answer.
I'm a bit confused because when we started here, either before or after I interrupted, not contest that all parties have standing.
Shares in Crypto Company Limited, and Crypto Company Limited had 90%.
The second claimant will.
Between Crypto Company Limited and Crypto Marketing Company Limited has been.
Do not have understanding for this tribunal. But also, when interrogated, you also say